Hey class, welcome to week 8. Kind of hard to believe that we are already so far into the semester. This week we are going to take a look at agency investigations. And while our textbook mentions civil lawsuits, including issues of standing, in this week's reading, we're actually going to examine those topics in depth later this semester. So this week we are only focusing on agency enforcement of laws through inspections and testing and other forms of investigations. So as we discuss agency investigations, keep in mind that agency regulatory schemes mirror our criminal law scheme, and some of the same constitutional requirements apply. So administrative agencies involved in investigations need to be aware of the constraints imposed by the Constitution, particularly the Fourth and Fifth Amendments. Regulated parties have the right under the Fourth Amendment to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and that means that agency investigators may need to obtain a warrant before inspecting premises or engaging in other types of searches or seizures. Regulated parties also have a Fifth Amendment right against self-incrimination. Additionally, there are sometimes parallel proceedings happening, and the government cannot use the administrative process as a loophole to circumvent constitutional protections related to the criminal process. So if the government is engaged in parallel proceedings, that is, it's running a criminal investigation as well as an administrative one, then the administrative investigation cannot help out that criminal investigation. So the first type of agency investigation is fairly simple data collection. The vast majority of agency investigations that I've encountered in my career have been data collection and review. And that's not to say that the investigation is not burdensome. I have worked on investigations where the organization's got to turn over hundreds of thousands of documents. So it can be very burdensome. It's just that in this type of investigation, information collection, it really never proceeds beyond the organization providing information to the federal agency for its review. So let's think about why agencies even need to collect information in the first place. That information tends to be essential to agency decision making. Agencies depend on information when they are creating regulations, adjudicating cases, and generally carrying out their mandates. Most importantly, agencies require information so that they can properly monitor compliance with various laws and regulations. Now, the public also benefits from informed agencies because the better informed, what we hope is, the better decisions that the agency will make. Private organizations also benefit from proper record keeping. A complete, comprehensive, well-maintained record system is one of the best CYAs around. I'll tell you that from an attorney perspective. So the need for information means that record keeping and reporting are major parts of life in an agency and within regulated parties. So individuals, businesses, nonprofits, universities, for-profits, all of these types of organizations have to collect information about themselves and maintain those records in some type of prescribed format. And regulated parties typically have to engage in both record keeping and reporting. So let's take a look at those two methods of information gathering. In record keeping, a regulated party has to maintain orderly records, again, usually in a certain format, and the agency can come in and review those records at the agency's request. So normally that's during regular business hours. A lot of times now it is just through electronic document sharing. With record keeping, if the agency never asks to see the records, then the regulated party never has to provide them. In reporting, on the other hand, the regulated party has to affirmatively provide specific records to the agency at specific times. So these methods of information collection, they are not just for situations where an agency thinks that an organization might be non-compliant. Record keeping and reporting are almost always required even where organizations are in full compliance with the law. As an example, Recipients of federal research grants and other federally funded research awards, like universities, have to maintain records of approved spending, human subject protection compliance or animal welfare compliance, conflict of interest compliance, etc. And at any point, the sponsor funding agency can come and examine those records. Additionally, the same recipients, so again, let's think of a university, have to provide monthly, quarterly, and annual reports to the agency. And these reports are both technical reports about research progress and also financial reports about how the organization is spending public money. Now, most agencies have broad informal and formal authority to collect information from regulated parties, people and organizations. And again, that is even where the agency does not think that the regulated party has violated any type of statute or regulation. You can safely assume that almost every agency out there has some form of record keeping and reporting requirement. Now, agencies do not get this authority from the Administrative Procedure Act. Congress has to grant that authority to agencies via some other statute. So an agency's enabling statute or some other controlling statute that defines the agency's jurisdiction will often grant information collection authority. And agencies usually broadly interpret that jurisdiction, and the courts usually agree, so long as the agency's information collection is not exceeding that jurisdiction authorized by Congress. So agencies can generally require record keeping or reporting so long as the agency's got jurisdiction over the party and the subject. The reporting requirements, the record keeping requirements are reasonable and they are not overly burdensome. And the information kept or provided to the agency is not privileged. Organizations can be excused from this type of compliance if the cost of compliance is extremely high or if the organization is going to suffer harm as a result of such compliance. And so, for instance, that might be the disclosure of trade secrets, which we'll talk about in a moment. Now, there are costs of reporting. This type of compliance does cost money. Small businesses alone spend nearly 1 billion with a B, 1 billion hours and $100 million per year filling out federal government forms. So again, if you look at a basic research grant to a university, that university's got to file monthly, quarterly, yearly, and final financial reports, yearly audited financial statements, monthly and yearly and final performance reports, yearly lobbying reports, yearly and final property reports, reports on subcontractors, reports on procurements, and things like reports on efforts to utilize small or disadvantaged businesses. In addition to collecting and often providing that information, organizations have to keep their records for anywhere from 3 to 10 years after they were last modified and used. So while reporting costs money, compliance for information collecting costs money, it also saves money. There are long-term financial benefits to record keeping and reporting. So the EPA actually did a study on this, and according to the EPA's records, businesses spent $523 million to comply with the Clean Air Act. This is over the period of a few years. But they saved $41 trillion in healthcare costs. Additionally, the EPA estimates that organizations spend $65 billion annually to comply with the Clean Air Act amendments, but the economic value of that compliance is nearly $2 trillion per year. It also behooves organizations to engage in record keeping and reporting because doing so can avoid lengthy and costly audits, administrative actions and investigations, or fines and other penalties. So there are definitely benefits to reporting. This type of compliance can save a lot of money, not only for the organization, but also public taxpayer money. I had mentioned that organizations are exempt from reporting information that might be privileged. So protections for privileged information come from the U.S. Constitution, state constitutions, statutes, and the common law. Those common law privileges can vary by jurisdiction, unless, of course, they are set forth by the U.S. Supreme Court. So trade secrets, this is a major category of information that organizations do not have to report to the federal government. Trade secrets are information that could include formulas, patterns, compilations, programs, devices, methods, techniques, or processes that derive independent economic value. That can be actual value or potential value, and they derive that value from not being generally known or readily accessible to other people. And the subject of the efforts, that information that's a trade secret, the organization has to use reasonable efforts to maintain its secrecy. So for example, the local health inspector can require the local KFC to hand over records like food delivery schedules and cleaning schedules, but that local health inspector cannot force KFC to give up the Colonel's secret recipe because that information is privileged as a trade secret. So again, some of these protections come from statute. And so, for instance, there's the Economic Espionage Act of 1996 that criminalizes certain misappropriations of trade secrets. So if, for instance, an individual steals a trade secret and uses it to benefit a foreign power, they can be fined up to $500,000 per offense and imprisoned for up to 15 years. Companies that violate this act can be fined up to $10 million. There is also the Uniform Trade Secrets Act. It's a model code, but it's been adopted by 47 different states. The only states who have not adopted it are New York, North Carolina, and Massachusetts, but they have their own trade secret laws that are very similar to this Uniform Trade Secrets Act. There's also a Defend Trade Secrets Act, basically allows the owner of a trade secret to sue in court if its trade secrets have been misappropriated. And then there are other statutes that recognize specific trade secret exemptions. So for instance, there are some environmental laws that require record keeping and reporting, but they do protect trade secrets. Basically, the regulated party can mark portions of its records or reports as confidential or trade secrets. And so they can submit it with the confidential markings, and they can submit that information separately from the rest of the records. And so government agencies, if they obtain trade secrets because of a statutory reporting requirement, they are required by law to protect those trade secrets. They cannot give them to anybody else. They cannot disclose them in response to, for example, a FOIA request. Now, on the environmental law side, it kind of gets interesting as to whether hazardous chemicals can be considered a trade secret. And the answer is yes, they can. So a company like DuPont or Monsanto can assert a trade secret protection, but that company's got to be able to prove to the feds that that chemical composition, that toxic chemical, really is a trade secret. And in today's world, the ingredients of most chemical products can be determined pretty easily in laboratories by means of like gas chromatography or other types of scientific tests. If information is really easily discoverable by reverse engineering or chemical testing, it is doubtful that it could be considered a trade secret. Additionally, in toxic tort cases where people are injured, say by chemicals seeping into the groundwater, if you think of something like Aaron Brockovich, chemicals that cause an injury, those are no longer protected by trade secret laws or other doctrines. There are other laws that provide the public and local governments with information concerning potential chemical hazards that are present in their communities. So again, these laws, they allow for the protection of trade secrets if a company's got a hazardous chemical, but not to such an extent that the public is put in danger. Additionally, Occupational Safety and Health Administration has hazard communication standards, and that requires organizations that are employers to communicate the specifics about hazardous substances to their employees. So even if those are trade secrets. Now, those employees might have to sign confidentiality agreements and such, but they have to know what they're dealing with so that they can take appropriate protections. Various common law doctrines also protect privileged information, and particularly communications. And a privileged communication is a legal principle that restricts certain people who hold positions of trust from divulging information that was told to them by a person who has sought them out because of their position of trust. So if you watch Law & Order or other cop shows, you've obviously seen attorney-client privilege, but there are additional privileges as well. And so privilege normally comes up in court because typically, if you're called on to testify in court and you refuse, you will be held in contempt. But if you refuse because of a privilege, you can't be forced to divulge that information. So the most common types of privilege are attorney-client privilege, accountant-client privilege, spousal privilege, which is not as broad as people think. The communication has to be germane to the married relationship. There is doctor-patient privilege that applies to all sorts of health professionals, so includes psychiatrists, psychologists, therapists, etc. And then there is this confessional privilege. Basically, it used to be called priest-penitent privilege, sometimes it still is, and that is between a religious professional, doesn't have to be a priest, could be a pastor, rabbi, imam, what have you, and one of their parishioners. So privilege works to protect the person who communicates the confidential information, not the person who is receiving the information. So for example, if Karen is my client and I'm an attorney, and we're, handling a divorce case, and Karen tells me that she was cheating on her husband, I cannot reveal that information. Karen can decide to, but it is not my place to do so. And if you think about it, privilege works because if these types of conversations weren't privileged, no one would feel safe talking confidentially to a trusted professional. So making a confession to a priest or telling an attorney about your legal concerns just wouldn't be possible if that priest or that attorney could then divulge them. In the case of healthcare professionals, they could not do their jobs without confidential information, from their patients. Patients don't want to talk about things like drug or alcohol use or potentially STDs if they know that that information can be disclosed. So each state has different laws about what types of communications and relationships are privileged. Some states, well, all states do recognize the privileges listed here, but some states provide additional privileges. Now, to be privileged, that communication has to be between the person and their professional advisor. And that professional advisor has to be acting in their professional capacity. The communication is no longer privileged if the person who divulged the information to their trusted professional communicates it to others. So again, if Karen tells her best friend about the cheating, then, I as the attorney, I'm not the only one who knows about it, and so privilege does not apply. With variations in different states, the privilege might be waived by courts in certain circumstances. Typically, if the person is in danger of harming himself or others, himself, herself, or others, if they share information, again, with other people, or if the person is a minor and is the subject of a custody dispute. So there are limits on privilege. The Fifth Amendment provides us all with the privilege against self-incrimination. So that's another type of privilege. An individual can't be forced to provide information, verbally or in writing, that can then be used to prove their guilt. But if you think about the requirements for information collection, for record keeping and reporting, agencies might require individuals or organizations to keep and/or report incriminating records. So for instance, if you're a medical marijuana patient, well, marijuana is still illegal at the federal level, but in order to be a medical marijuana patient in Colorado or Maryland or other states that have medical marijuana laws, you have got to provide certain information in writing to the state. In order to claim a Fifth Amendment privilege and not provide that information, you have to reasonably believe that if you provide that information, it could be used against you in a criminal prosecution. So if the information cannot be given to law enforcement or to prosecutorial agencies, then you don't have a reasonable belief that prosecution will result. So again, for example, in Colorado, those medical marijuana records are confidential and privileged and cannot be turned over to law enforcement agencies. So by providing that information, you don't have a reasonable expectation that you're going to be prosecuted, and so you cannot claim that Fifth Amendment privilege against self-incrimination. It is also important to realize that the Fifth Amendment is not always applicable. The Fifth Amendment privilege against self-incrimination does not apply to business entities. It does not apply to information that is already in the possession of a third party, unless, of course, there's that type of privilege that applies. And it doesn't apply to an individual's or an organization's voluntary collection of incriminating information. So, for example, the mafia keeps really good records, and sometimes those records get used against members of the mob at trial. The information's incriminating, but it's admissible at trial because the government did not compel the mafia to keep those records. It was voluntary. Also, the Fifth Amendment privilege against self-incrimination can be overcome by a valid grant of immunity by the government. So with a valid grant of immunity, and at the federal level that has to be approved by the Attorney General, the individual no longer has that reasonable belief that the information will be used against them for prosecution. And in that case, they can be compelled to testify. There are two types of immunity in use today: transactional immunity and derivative use immunity. Transactional immunity, that provides complete and total immunity for all offenses that are related to the individual's testimony, even if law enforcement or prosecutors can independently obtain evidence that proves that person's guilt. Transactional immunity, it exceeds the Fifth Amendment's requirements, and a witness who has a valid grant of transactional immunity can be forced to provide self-incriminating testimony because that testimony cannot be used against them, nor can any independently obtained evidence related to their testimony. Derivative use immunity is an incomplete form of immunity, but it is constitutionally adequate. It meets Fifth Amendment standards. In derivative use immunity, nothing that the individual says can be used against them, nor can evidence derived from their testimony be used against them, but independently obtained evidence can be used against them. So the police or prosecutors can't listen to the person's testimony, say, aha, and then go search a place and get evidence against them. However, if there's, say, a confidential informant who provides that information, then the police can go and search that place, and they can use that information against the person testifying. There is a form of immunity called use immunity, but it does not meet the Fifth Amendment's minimum standards, and so it is unconstitutional. Use immunity, that was an incomplete immunity. Basically, the individual's testimony couldn't be used against them, but the evidence derived from that testimony could be, and so obviously that does create an issue of self-incrimination. So agencies can investigate by collecting information from regulated parties, and as I said, that's not necessarily a simple thing. An investigation based on information collection can be very burdensome. But agencies can also investigate through in-person inspections, searches, or by requiring certain tests. Here on the slide, you can see the FDA's Investigations Operations Manual for 2020. Every agency that engages in investigations should have something like this. They should have some type of manual that constrains the discretion of investigators. So agencies conduct these inspections and tests, again, to monitor compliance with laws and regulations. And with inspections and tests, a lot of times the goal is to protect the health and welfare of employees, customers, and the general public. So for example, the EPA or a state department of the environment can conduct scientific tests of toxic disposal facilities or tests of lakes and rivers downstream from those facilities or from mines or from power plants, anything that, that might endanger the environment or human health. Agencies also conduct inspections by viewing records, but by being physically present at the regulated party's location to view those records, as well as to just review the physical premises. So if you would think about like an OSHA inspection of a manufacturing facility. Agencies have to be authorized by statute to conduct inspections and tests, but as with information collection, it's not the Administrative Procedure Act that provides this authority. Congress has to grant this authority to agencies via other statutes. Also similar to information collection, agencies conduct inspections and tests even when there's no suspicion that a regulated party has violated a statute or a regulation. It's important to distinguish between criminal investigations and administrative investigations. Both criminal investigatory agencies and administrative investigatory agencies are constrained by the Fourth Amendment. Law enforcement agencies, agencies that are investigating criminal violations, have to strictly comply with the Fourth Amendment, but non-law enforcement agencies comply with the Fourth Amendment, but those requirements are somewhat relaxed. Now, there are many different types of investigations. Criminal investigations, obviously, those are looking into allegations of criminal misconduct, while administrative investigations are looking into regulatory noncompliance that does not rise to criminal levels. You can have both. You can violate regulations to a degree that that violation is also a crime. Now, administrative investigations can be compliance checks, financial audits, equal opportunity investigations, safety inspections, background investigations, etc. Federal and state regulatory agencies like the EPA or OSHA, as well as their state counterparts, often engage in inspections and tests that are designed to protect the public health and the environment. Again, testing for water contaminants or looking for unsafe manufacturing conditions. For criminal investigations, there are the obvious investigatory agencies, the FBI, DEA, other agencies within the Department of Justice, as well as Department of Homeland Security agencies like ICE. But many administrative agencies that we don't think of as involved in criminal investigations do actually have the power to investigate certain crimes. Those agencies will turn the criminal cases over to the DOJ for prosecution, but they handle the investigations on their own. So for instance, the EPA has its own special agents, same as the FBI. The IRS, the Postal Service, the Fish and Wildlife Service, they all have criminal investigatory offices. And then there are various offices of Inspector General, which are within various agencies, and they are typically focused on fraud, waste, and abuse, such as violations of the Criminal False Claims Act. In addition to those criminal investigatory agencies, there are tons and tons of federal, state, and local regulatory agencies charged with protecting the public health and safety. So the Food and Drug Administration, EPA, OSHA, Mine Safety and Health Administration, Nuclear Regulatory Commission, and the Department of Education. These are just a few agencies that carry out administrative investigations via site inspections and tests. So again, EPA can conduct scientific tests at various facilities. OSHA can conduct site inspections at facilities. And then at the state and local level, there are fire marshals, there's health inspections at restaurants, building code inspections, safety inspections, home inspections carried out by social workers, to make sure that minor children are safe, and a whole variety of other inspections for state or municipal code compliance. You can see at the bottom right, that is a City of Boulder code enforcement officer. She's out inspecting the sidewalks and citing homeowners for failure to clear snow and ice off the sidewalks in front of their houses. Now, unlike information collecting, so unlike record keeping and reporting, inspections don't usually cause organizations to incur significant monetary expenses. Now, I say usually because, of course, a detailed inspection can be very costly for an organization. But on average, inspections don't take nearly as much time as record keeping and reporting. They usually take place during regular business hours. They can last, from anywhere from like 15 minutes to several days. Inspections do represent a much greater invasion of privacy, though, and so that is its own cost. Administrative agency inspections can be searches under the Fourth Amendment. Administrative searches and seizures can even be something as simple as, gathering up some water to run a test. They have to be reasonable, and they often require an administrative warrant. Now, administrative inspections do not trigger full Fourth Amendment protections against searches and seizures, and that's because administrative inspections are designed to uncover violations of administrative codes, not violations of criminal law. Additionally, regulatory agencies really have to engage in inspections in order to meet their statutory mandates to monitor compliance with the law. So we've got to allow them to come in and inspect, and they can't necessarily do that if they have to fully comply with the Fourth Amendment the way that a law enforcement agency does. Additionally, another reason that full Fourth Amendment protections don't usually apply to administrative inspections is because most businesses are considered public operations, and there's just a lower expectation of privacy in public operations. If you're running a restaurant, people are coming in all the time. Not right now necessarily because of COVID, but in general, you've got people in and out of the restaurant. There's just not a lot of expectation that you can engage in anything private. The more regulations that apply to an organization, the less they have a legitimate expectation of privacy. If you are a nuclear power plant manager, you can pretty much assume that the NRC can show up at any time to make sure that your plant is operating safely. Now, not all inspections are searches. So for example, observations made by agency officials in public places, those are not searches because, as we just said, public places create no reasonable expectation of privacy. So inspections are agency visits that are designed to determine that a regulated party is meeting some expected level of compliance. An inspection could simply be, the local health inspector comes into the Chipotle, looks around, sees that everything in the public area looks okay. Searches are where agencies visit to look for a particular condition that would constitute a violation of law. Now, agencies don't necessarily think that that particular condition exists, but in order to monitor compliance, they have to go look for it. So an inspection turns into a search when the agency official inspects an area in which the owner, the person possessing the property, or a legal occupant of the property has a reasonable expectation of privacy. And that includes private offices, even if those are adjacent to public places. So the local health inspector can come in, take a look all around the public part of Chipotle, but they can't go into that door marked private staff only unless they've got an administrative warrant. Now, in criminal cases, that warrant has to be issued based on probable cause. This standard is relaxed in administrative searches. Agencies only have to show a legitimate cause in order to get an administrative warrant. And to have a legitimate cause, the agency needs a valid public interest in enforcing its regulations via a search. Now, certain non-law enforcement regulatory agencies don't even need to show legitimate cause to receive an administrative warrant. An agency does not need legitimate cause to inspect a closely regulated business if the legislature has established reasonable inspection standards. We'll talk about that in just a moment. On the slide here, you can see the Commonwealth of Pennsylvania's application for an administrative search warrant. Criminal warrants, they have to state the particular place to be searched and items to be seized. I'm going to search Jen Gartner's house, specifically her basement, and I'm looking for, her stash of illegal betting machines, something like that. But this standard, again, is relaxed in administrative searches. So agencies still have to provide information about the area to be searched, and they've got to provide information about the agency official conducting the search, but they don't have to do this very specific area search description as required in a criminal warrant. Instead, administrative agencies can get area warrants that allow them to inspect a general area. And on this slide, you can see the state of Tennessee's administrative inspection warrant. So as I said, like 2 slides ago, agencies can get a warrant to inspect a closely regulated business without having to show legitimate cause. So closely regulated businesses are those within industries that are subject to significant licensing, reporting, inspection, operating, and disclosure requirements. So that includes, but it is not limited to, nuclear power plants, liquor sales, firearm sales, and restaurants. So for these closely regulated businesses, there's a significant public interest that merits special attention and thus enhanced regulation. And usually that public interest is safety, be it food safety, manufacturing safety, building safety, or environmental safety. And the reason that these agencies don't have to show legitimate cause to obtain a warrant is because that legitimate cause is pretty much baked into the agency's statutory mandate. And the NRC has to go and inspect nuclear power plants for public safety. It doesn't always need to explain why it has to inspect nuclear power plants because it's pretty obvious. Agencies that inspect these closely regulated businesses, they can only get that warrant without showing legitimate cause if the legislature has established reasonable inspection standards. And to be reasonable, the agency has to show that the inspections are vital to that agency's ability to enforce or otherwise assure compliance with health, safety, sanitation, housing, employment, or other laws. And also the regulated business must be aware of the inspection standards. So for instance, at the University of Maryland College Park campus, we had a nuclear research reactor, so we are subject to NRC inspections on a very regular basis. But we know exactly what the NRC is looking for because they provide not only regulations, but a specific inspection manual. So regulatory agencies do not need to show legitimate cause in order to obtain a warrant to inspect a closely regulated business. Additionally, agencies can inspect these businesses without obtaining a warrant, so long as the government has a substantial interest in the business. That warrantless inspection furthers the government's substantial interest, and the legislature has created a reasonable statutory scheme that substitutes for the warrant procedure. That reasonable statutory scheme has to be narrowly tailored to achieve the government's interests. It's got to basically be just and fair. And the exception to obtaining an administrative warrant, in these circumstances, it pretty much mirrors the public safety or exigent circumstances exceptions in criminal law. So in these cases, the time spent obtaining a warrant would put the public at risk, or it would make it impossible to obtain the evidence because it would dissipate. So you can think about this, if you get pulled over on the criminal side, because the police think that you are driving under the influence, they don't have to necessarily get a warrant to give you a breathalyzer test, because by the time they finally got one, the alcohol would have left, and so they wouldn't be able to obtain that evidence. Same sort of thing here for these warrantless inspections of closely regulated businesses. Now again, the law has to create a reasonable statutory scheme that substitutes for a warrant. And to be reasonable, that statutory scheme has to inform the business that regular inspections are going to be made. It has to set forth the scope of those inspections. It has to notify the business about how to comply with the law and who at the regulatory agency is authorized to conduct an inspection. And it has to limit the time, the place, and the scope of the inspection, basically to impose appropriate constraints on the inspecting officer's discretion. So again, this is where we want to make sure that agencies are not abusing their discretion. Agencies also engage in mandatory testing for drug or alcohol use, also sometimes for infectious diseases. Mandatory testing, it does raise constitutional questions, particularly if the government is the one performing the test, or if the government gets to see the results in the case where an employer has to perform the mandatory test. So there are questions like, is a mandatory test a search under the Fourth Amendment? Does the agency have to have probable cause for requiring mandatory testing? Do they have to obtain a warrant before testing? Does requiring an individual to submit breath, blood, hair, or urine for a test, does that violate their liberty interest under the Due Process Clause? Well, mandatory testing, it is a search under the Fourth Amendment. Agencies may need to obtain an administrative warrant. But again, because this type of testing is not intended to uncover and prosecute criminal violations, the standards are relaxed. Additionally, the government can promulgate regulations that require private companies to warrantly test employees if those regulations limit the employer's discretion to test, usually by specifying which employees can be tested and under what circumstances. If the government's interest in protecting employees or the public outweighs the individual's privacy interest, if the government's objective is administrative, not punitive, if the evidence would dissipate in the time that it takes to get a warrant, and if the regulations minimize the privacy invasion. So if you think about if a train runs off the tracks and crashes, the employer will have to go and do a drug test of the train operator just to make sure that that was not part of the reason for the crash. And that is a warrantless test, but there are regulations in place to protect that train operator's interests. There are also times when the government has a special need to drug test employees or government contractors or other individuals, and that special need makes it impractical to obtain a warrant. So for instance, employees who are routinely exposed to controlled substances, like DEA agents, they can be randomly tested without a warrant. So can employees who are routinely exposed to organized crime, employees who have access to classified information, employees who carry weapons, or employees who are responsible for vulnerable populations. So that includes school children, prisoners, the infirm, and the elderly. So in summary, if an inspection or test encroaches on a person's expectation of privacy, it is a Fourth Amendment search. If the objective of the inspection or test is administrative, not the detection or prosecution of a crime, then the inspection or test just has to be reasonable under the Fourth Amendment. There is no need to meet the Fourth Amendment's probable cause requirement. If the individual or the organization is not a closely regulated business, the agency must have an administrative warrant to do that inspection or take that test. If the organization is a closely regulated business, a warrant is not required so long as the legislature has provided a reasonable statutory scheme. And in general, the more invasive the procedure, the greater the government's interest will be to satisfy the Fourth Amendment. A blood test, that is more invasive than a breathalyzer test, for instance, and so there are additional Fourth Amendment restrictions. Let's take a look, since we're talking about investigations, about the various investigations into the 2007-2008 financial crisis, the one that gave rise to the Consumer Financial Protection Bureau. So you can see a quote from then FBI Director Robert Mueller. He said, the prevailing thought process seemed to be, everybody's making money, why should we miss the boat? But few people ever believed that that boat might sink. Well, obviously that boat did sink. And early on in the crisis, the FBI did start criminal investigations into thousands of cases that represented billions of dollars in losses. So a year or two into the financial crisis, the FBI had investigated 2,400 mortgage fraud cases, 580 cases of corporate fraud, 1,300 security fraud cases, and over 3,000 public corruption cases that ultimately led to convictions of 1,700 government personnel. Also in 2009, Congress passed the Fraud Enforcement and Recovery Act, and that act created a 10-member Financial Crisis Inquiry Commission. And that commission was able to begin its investigation while the fallout from that financial crisis was continuing to rock the economy. It held hearings throughout 2010. The commission then submitted its report to the Senate Permanent Subcommittee on Investigations, which in April of 2011 released that report. It was 639 pages long, called Wall Street and the Financial Crisis: Anatomy of a Financial Collapse. And in that report, the commission concluded that the financial crisis was avoidable, that the federal government was ill prepared for the crisis, and that the federal government's inconsistent response added to the panic. The commission also found that widespread failures in financial regulation and government supervision proved devastating to the stability of our financial markets, and that there was an overall breakdown in accountability and ethics. The Federal Office of Thrift Supervision, OTS, that was cited in the report as a major culprit in the financial collapse because it failed to stop unsafe and unsound practices that led to the demise of Washington Mutual and then other banks and mortgage brokers. The Dodd-Frank Wall Street Reform Act wound up eliminating OTS, and it instead granted regulatory authority to the Securities and Exchange Commission, the Commodity Futures Trading Commission, and the Consumer Financial Protection Bureau. So in A Fighting Chance, Elizabeth Warren leaves the story of the Consumer Financial Protection Bureau pretty shortly after the Bureau begins its many different enforcement actions. So now Senator Warren, but at the time not, just Professor Warren, she notes in the book that the team set up the Bureau pretty much without a hitch, and that in its first 2 years, the Bureau would recover nearly $500 million for consumers, and it would also save thousands of homes of service members who were deployed in Afghanistan and Iraq. By June of 2013, over 175,000 people had already turned to the CFPB's consumer hotline for assistance with credit cards, student loans, and mortgages. So we are now more than 10 years on from the 2007-2008 financial crisis, but many people are still feeling the after effects. However, a lot of folks don't realize that there were many agencies within the federal government that investigated various actors in the financial crisis, and administrative agencies in particular obtained hundreds of billions of dollars from the people who created or benefited from that crisis. Now, the Department of Justice was able to convict some people for financial crimes, but they were not able to convict any major bankers. I think maybe there was one banker, a top CEO, who went to prison. Now, this was not for lack of trying, it's just that it's very difficult to prove criminal intent and guilt beyond a reasonable doubt in the fallout from our financial crisis. Now, on the other hand, the DOJ obtained $60 billion in civil settlements with large banks. The DOJ, HUD, and state attorneys general obtained another $25 billion in settlements with the largest mortgage lenders. Additionally, the SEC obtained about $4 billion through civil lawsuits and administrative charges, and the Consumer Financial Protection Bureau recovered a whopping $12 billion for consumers and hit Wells Fargo specifically with a $100 million fine for fraudulently opening consumer accounts. So you can see that the results of all of these government investigations, specifically administrative investigations, actually did bear fruit and did help those of us, consumers and the public who were injured by the financial crisis. That's not to say that everybody was made whole, because certainly they weren't, but the government, at the federal agency level and also state governments, really did run some lengthy and detailed investigations and were able to enforce certain laws and recover money. Okay, that is it for this week's lecture. You will notice in the classroom that our weekly readings have changed. That is to keep up with sort of applicable current events. I was going to have us focus on some investigations by the Consumer Financial Protection Bureau, but instead we're going to take a look in our discussion at the Department of Education's recently opened investigation into Princeton University for its admission of systemic racism. So that's what we're going to discuss in discussion number 6. Your first memo is also due at the end of this week. In that memo, you've got to advise the DEA administrator about regulating a new addictive drug called NZT. Remember, there is a collaborative discussion board available, so you can help each other out with the assignment. Okay, thank you so much for listening, and have a great week, and I will see you on the discussion boards.